Good evening, everyone. Thank you. Welcome. My name is Troy McKenzie. I am fortunate enough to be the dean of this law school, and thank you for joining us for the 2022 James Madison Lecture. The Madison Lecture is one of our most esteemed public lectures and also the longest-running lecture series we offer at NYU Law. The first Madison Lecture was delivered in 1960 by Justice Hugo Black of the Supreme Court of the United States. And it was during that lecture that he famously illustrated his theory of categorical protection of free speech. Since then, we've been fortunate that the Madison Lecture has provided a forum for our nation's jurists to present their vision of the law to our community and to the broader legal world. This lecture series would not be possible without the work over many years of my late colleague, Norman Dorsey. Norman was the Frederick and Grace Stokes Professor of Law, and for decades, he was the director of the Madison Lecture, which he ran from 1977 until his death in 2017. He was a defender of civil liberties, and he was also dedicated to the work of the judiciary. And over the years, he helped to make the Madison Lecture the great forum that it is today. I would also like to recognize the work of some other colleagues, including Stephen Gillers, who was at the helm of the Madison Lecture until his recent retirement from our faculty. And I would also like to recognize the current faculty co-directors of the Arthur Garfield Hays Civil Liberties Program, which has been closely linked to the Madison Lecture over the years. The Hays program is now ably co-directed by the amazing and dynamic Helen Hirschkoff and Deborah Archer, and Professor Emerita Sylvia Law. But before I introduce this evening's speaker, Chief Judge David Barron, please let me invoke a point of personal privilege. I would like to acknowledge Judge Pierre N. Laval of the U.S. Court of Appeals for the Second Circuit. Many of you may recall that Judge Laval was our Madison lecturer in 2005, where he gave a lecture entitled Judging Under the Constitution, Dicta About Dicta. It was immediately cited by Justice Stephen Breyer in two cases, Scott against Harris and Morse against Frederick, and the forceful logic of that lecture ultimately persuaded the Supreme Court of the United States to retreat from its approach to qualified immunity cases that had been laid out in Saussure against Katz. I know Judge Laval not as a Madison lecturer, but as boss, and it's wonderful to see him here in the audience this evening. Now on to our speaker. David J. Barron is the Chief Judge of the U.S. Court of Appeals for the First Circuit. Chief Judge Barron joined the Court of Appeals in May 2014 and became Chief Judge this past year. He has had a storied career even before he came to the bench. He was a member of the faculty of the Harvard Law School, which he joined in 1999, and where he served as the S. William Green Professor of Public Law. In 2009, he became Acting Assistant Attorney General in charge of the Office of Legal Counsel at the Department of Justice. He returned to the Harvard Law faculty after serving 2 eventful years at DOJ. Then Professor Barron's scholarship and teaching were focused on state and local government law, administrative law, constitutional law, and presidential powers. On a more personal note, I think of Chief Judge Barron as part of the family of law clerks of the late Justice John Paul Stevens. And I have a particularly vivid memory from May 2019, a few months before the justice died at the age of 99. The justice held in that month what turned out to be his final law clerk reunion. We all went down to Fort Lauderdale to see him. He had been spending much of his time in retirement there. But of course, Justice Stevens' retirement was far more active than most other people's busiest days. He had just published his memoirs, The Making of a Justice, in 2019. And Chief Judge Barron served as the anchor in a conversation about the book with the justice. The conversation that evening was classic John Paul Stevens and classic David Barron. Unpretentious but highly illuminating, insightful but plain-spoken, erudite but down to earth. So as someone who knows and admires your work, I'm very honored to have you here tonight, Chief Judge Barron, and thank you for taking the time to join us. One final preliminary. I want to note that tonight's lecture offers CLE credit. I know that's not why you're here, but just in case, if you are seeking CLE credit, please be sure to sign in and sign out on the CLE sheets, which are posted at the registration desk immediately outside this room. The title of Chief Judge Barron's lecture this evening is The Court of History. Please join me in welcoming Chief Judge David Barron.
Well, welcome, and thank you all for coming this evening. And I really appreciate the remarks. Dean Mackenzie, Justice Stevens meant a great deal to me, and it's a real honor to be giving a lecture that both he gave and my other judge, who I admired so much, Judge Stephen Reinhardt, also gave. I want to thank the NYU School of Law and the sponsors of the Madison Lecture, and particularly Professor Gillers and former Dean Trevor Morrison. I enjoyed working with Trevor in government and learning from his own scholarship, including his writing on a topic related to my own tonight. I want to acknowledge, too, my fellow judges who are here and the circuit executive for my circuit, Susan Goldberg, who's also present. And I'm grateful to have both of my parents here, two of my children, my in-laws, along with friends and a number of former clerks. And I want to say a special word of thanks to my wife, Juliet Kayam, and to my father, Jerome Barron, who helped me think through the ideas that I'll be sharing this evening. I'm reminded of a conference I attended in China while I was still in teaching. It was at Beijing University, and it began with introductory remarks in Chinese. They were met with great laughter. Fortunately, a translation in English immediately followed. Nothing interesting is said in open session. There's the risk for a sitting judge of saying nothing of interest. There is also the risk of saying something too much of interest. Other Madison lecturers, including from my own circuit, Judges Sandra Lynch and Michael Boudin, have managed to negotiate that difficulty, and I aim to do so too. The Court of History. What is a court's relationship to history? From the earliest days of the Warren Court until relatively recently, the loudest critics of our courts have had a ready answer. A court, to be a court, must look to the past, not the present, and certainly not the future. They've argued that a court, to be a court, must look to texts already enacted, meanings already fixed, intentions already expressed, or traditions already established. And so these critics have contended, whether championing originalism or textualism or some mix of the two, that a court, to be a court, must be a court of history. This answer has proved influential if the close of the Supreme Court's last term is a sign. In June, the court in Dobbs versus Jackson Women's Health Organization rejected the fundamental right to abortion by overruling Roe v. Wade and Planned Parenthood versus Casey. The court held in doing so that a right to liberty is no right at all unless it was already, quote, deeply rooted in history, unquote, at the time of the Due Process Clause's ratification. That same week, the court held that a federal or state limitation on the Second Amendment right to keep and bear arms is constitutional only if it was already rooted in a, quote, historical tradition established by the time that the 14th Amendment had been ratified. And days later, in West Virginia versus EPA, the court struck down an Environmental Protection Agency plan to address climate change by holding significant exercises of agency power unlawful unless Congress clearly had those exercises already in view when the agency was first empowered, no matter how long ago that was. Despite the seeming ascendancy of this backward-looking answer to my opening question about how a court relates to history, and that answer's assumption that history is always past, I want to explore a different and less familiar answer. This answer views history differently by cautioning courts to attend to history's future judgment, and not just to the record that history provides of what came before. It thus suggests that courts, in relating to history, must do more than excavate it. They must anticipate it too. And so this answer suggests that history requires courts, if they wish to judge well, to look forward and not just back, to be not just what I will call a court of history past, but also to be mindful of what I will refer to as the court of history future. By looking side by side at the court of history future and the court of history past, I hope to give a fuller picture of what it means for a court to relate to history and to keep it in mind. I also hope to capture what it feels like to judge betwixt and between these two ideas of a court of history, the one seemingly all the rage at present, and the other itself long part of American law, but of late too little acknowledged, let alone defended. From my own experience as a judge, I find resonant an analogy from the world of poetry that I hope will give you a sense of what I have in mind. The literary critic Harold Bloom famously argued that strong poets are plagued by the anxiety that they are merely rewriting the poems that were already written. And to assuage what he called, quote, the anxiety of influence, unquote, he argued that these poets creatively misread what came before them to claim their creativity for posterity. Judges are hardly poets. Indeed, they are obliged to respect precedent, so much so that a lower federal court judge like myself has no choice but to do so, no matter what, when that precedent comes from the Supreme Court. We thus might not expect judges to suffer from a similar anxiety of influence. But as we'll see, judges at all levels of the judicial system are quite aware that if the stakes of a case are high enough, history may come to judge their decisions harshly, no matter how faithful to the past the decision may have been. And so judges turn out to be no more immune from the anxiety of influence than poets, for they too have reason to worry about past's grip on them whenever they have discretion to make a choice. Might that mean that judges will also assuage the anxiety of influence through what we might call creative misreadings of what preceded them? I'll address that possibility at the end of my lecture by focusing on a type of misreading that is used to justify looking only back that I find especially concerning. But that's getting ahead of the story. To get us where I aim to go, I'll start in part one by offering some examples of how judges have appealed to the court of history's future judgment, and how they continue to do so to this day. I'll then explain in part two how these appeals differ in significant ways from appeals to present-day imperatives or policy preferences. And with that groundwork in place, in part three, I'll close with some suggestions about how judges can best manage the anxiety of influence that awareness of the court of history future occasions, in part by highlighting the type of misreading that judges who are trying to get us to look back must be especially careful to avoid because of how ahistorical I'll suggest that argument is. Part one. Do courts imagine that what I am calling a court of history future exists and that they are accountable to it? I think they do. Consider a startling passage from Trump versus Hawaii, the Supreme Court case that upheld President Trump's controversial executive order that, for asserted reasons of national security, barred persons from various designated countries from entering the United States. The court rejected the claim that the measure unconstitutionally discriminated against Muslims by effectively banning persons of that one religious faith from coming to this country. Along the way, Chief Justice Roberts, writing for the court, rejected Justice Sotomayor's charge in dissent that the majority was repeating the mistake that the court had made decades before when it blessed a World War II-era executive order and so allowed for the internment of Japanese Americans. The Chief Justice distinguished the two executive orders, but he also made this unusual statement about that earlier case, I'm sure known to all of you, Korematsu versus United States. The court had never formally overruled that case, and here is what the Chief Justice said. Korematsu was gravely wrong the day it was decided and has been overruled in the court of history. The Chief Justice did not say that the history that preceded the Constitution's ratification proved Korematsu was egregiously wrong as a matter of plain text or original meaning. He asserted only, as if such assertion were enough, that the history that had followed Korematsu had exposed it to be no precedent at all. It was as if that history, taught to generations of school children in Korematsu's wake, and culminating in congressional reparations to those interned, itself sufficed to reveal the shame, a word the Chief Justice has elsewhere used to describe the case, that Korematsu had brought upon the court from the day of its decision. It was as if that history warranted a judgment by the court of history, that the Supreme Court itself in the here and now was bound to follow, that the decision in Korematsu was henceforth a nullity. History does not appear in this passage from the Chief Justice as a chronicle of the past from which the Constitution's meaning may be derived. It appears as a future court that can and will expose the wrongness of an interpretation of the Constitution, once thought legitimate, but only after the lights of that court finally shine. The Chief Justice was relying there on a judgment that the court of history future had already made, and so one that he could find in history's record. But the future being what it is, a court of history's future's work is never done. Thus, an invocation of the court of history future inevitably raises the question whether courts making decisions today must try to anticipate the court of history's future judgments in the here and now, even though those judgments have not yet been made. Outside the courts, the verdictive presentation of history, in which posterity passes judgment on the present based on what it knows, is often used in just that anticipatory way. Those facing hard decisions with high stakes frequently point not just to future bad policy consequences that are presently foreseeable to them, but to history's impending harsh judgment to explain their choices, as if that future judgment itself is a thing to be avoided. Meanwhile, critics often condemn choices others are making, not just by taking issue with them on policy grounds, but by asserting they will fall on the wrong side of history when history has its say, as if history's harsh judgment is something especially to be avoided. This forward-looking way of deploying history as a guide to present action draws on the language of prospective condemnatory judgment, rather than policy preference or moral belief. It also speaks, as the theorist Joan Scott has emphasized, in the language of state authority, and so in a language that portrays the judge as deferring to the authority of a higher court, history's future judgment, and not imposing a policy or moral view of the judge's own. It thus uses language that judges like. Perhaps for this reason, judicial appeals to the court of history future are more common than you might think, though they do not all look like Chief Justice Roberts. Consider the one that popped up in another Supreme Court case not long after Trump v. Hawaii. The case concerned a religious freedom challenge to Nevada's power to stop the spread of COVID-19 by limiting the size of religious gatherings. Nevada relied on an early 20th century Supreme Court precedent, Jacobson versus Massachusetts, that had rejected a constitutional challenge to a requirement to be vaccinated against smallpox. Several justices saw merit to the challenge to the COVID-19 regulation, and one of them, Justice Kavanaugh, wrote separately to explain why Jacobson was not controlling. And here's what he said, quote, "This court's history is littered with unfortunate examples of overly broad judicial deference to the government when the government has invoked emergency powers and asserted crisis circumstances. The court of history has rejected those jurisprudential mistakes and cautions us against an unduly deferential judicial approach, especially when questions of racial discrimination, religious discrimination, or free speech are at stake," unquote. Justice Kavanaugh did not argue that late-breaking work in the archives had revealed that earlier judges had flunked the originalist or textualist test in making those earlier mistakes. He did not appeal, in other words, to the court of history past. He invoked the court of history future and the harsh judgment unfolding time had rendered. In fact, Justice Kavanaugh even warned that the court of history future would render that same judgment again unless the court rejected emergency power to address the spread of a virus in the case at hand. So unlike the Chief Justice, Justice Kavanaugh did not just rely on a judgment that the court of history future had already made to expose what had been wrong from the start. He invoked the prospect of a judgment that the Court of History Future would make down the line to show that in making a current choice between competing interests, a judge would prove more faithful to the law in time by making now in the present one kind of choice rather than another. Finally, consider an accusation that dissenting judges often make. The accusation is that in time, history will treat the majority's ruling the way it has treated the four precedents that Professor Jamal Green has referred to as the constitutional anti-canon: Korematsu, Dred Scott, Lochner, and Plessy versus Ferguson, the late 19th century case that upheld Jim Crow and was eventually overruled in Brown. Indeed, Justice Sotomayor made just this accusation by invoking Korematsu in Trump versus Hawaii. This notorious quartet does not symbolize a court gone wrong solely because the four decisions in it badly described the past. There are, in fact, serious scholarly debates about whether all of them did get the past wrong. The accusation packs its punch by highlighting the evident disdain that the Court of History Future has for those decisions and the way our law makes integral to it that disdain. Accusations like this anticipate history, but unlike Justice Kavanaugh's similarly anticipatory appeal to the Court of History Future, these accusations often seek to make way for the initial embrace of a new understanding of a legal principle that had long been defined in less inclusive terms. Of course, the use of history's future verdict as a guide to action is not easily contained once loosed. If it can overrule Korematsu, then why not Trump versus Hawaii itself? At the same time, if it can overrule cases that defer to emergency power, then why not cases that decline to do so? Indeed, if it can judge harshly those rulings that failed to anticipate the Court of History Future, then why not those that anticipated that court's future judgments with too little respect for the Court of History Past? As we'll see, that was the charge that was leveled at the Warren Court in its waning days. My point thus far, then, is not that history's future judgment runs in only one direction. It most certainly does not. Or even that it is a reliable guide. There are serious questions about how a judge could ever know how that court will judge. For now, I just want to convince you of a simple thing, that judges cannot help but be aware that they inevitably, if uneasily, sit between these two courts of history, the one that urges them to attend only to the record that history creates of the past, and the other that cautions them to be wary of the judgment that the history may render in the future. For I'll suggest, because judges sit between these two positions and occupy that uneasy position, they must decide how they will manage the anxiety of influence that results. Part 2. The forward-looking view of how courts relate to history that I have in mind might sound to you a lot like a defense of living constitutionalism or pragmatic consequentialism, which you might understandably associate with a focus on the needs of the present moment or preferred policy outcomes. It thus may sound to you more like a view of how courts should relate to the present or to policy, rather than of how they should relate to history, whether history in the sense of a record of the past or history in the sense of a judgment to be rendered in the future. But the argument for judging with the Court of History Future in mind is neither presentist nor policy-focused in aspiration. So before answering how courts account for the Court of History Future, and I will try to give you an answer, I want to explain this difference. The modern argument for a living constitution was most pithily made by Franklin Roosevelt when he attacked the Supreme Court of his day for what he called its horse and buggy conception of the Constitution. He used that antiquated image to chide the court for refusing to construe the Constitution to be fit for the times, given America's modern, urban, and industrial economy. Echoing Chief Justice Marshall's early 19th century admonition to construe the Constitution to be responsive to the various crises of human affairs that would befall the United States over time, Roosevelt sought to make room for present political innovation in the face of the current crisis that he faced, the Great Depression. He wanted the courts of his time to get out of the way, do less, defer to governmental power more, because he wanted them to permit law to be a workable instrument of government in the present. The argument for making room for contemporary democratic politics based on present imperatives is straightforward enough. It asks the judge just to leave the assessment of what to do in the face of present needs to those best equipped to make such assessments, those we've elected. Such a presentist argument is not easily repurposed as an argument for judges to constrain those very politics based on new understandings of constitutional limitations. If the constitutional constraint rests on accepting new understandings of an old constitutional principle, then isn't the constraint just a product of its times? And if so, then why not let the politics of the time assess the need for it? Such questions led many enamored of Roosevelt's interpretive approach during the New Deal to have great trouble in the decades that followed with the courts torn towards novel rights enforcement, and to Brown in particular, especially when the novel right rested on a new understanding of social relations rather than just a change in technological or economic circumstances. An appeal to the court of history future does not call to mind those same kinds of questions, and thus those same objections about the legitimacy of enforcing rights based on new understandings of the social world. And that is because the temporal orientation of the appeal differs from the temporal orientation of a defense of a living constitution that President Roosevelt championed. Its time horizon is longer because its basic aim is different. Its aim is to protect courts from the harsh decree of history that is to come, not to convince them to account for present imperatives. To see the difference, I offer 3 examples, one from a majority opinion, one from a concurring opinion, and one from a trenchant commentary on the Warren Court. The first example comes from the debate between the majority and the dissent in Romer versus Evans, a case about the rights of gay and lesbian persons from the Supreme Court that was decided in 1996 and from the majority opinion in it. The case concerned a challenge to a statewide referendum that prohibited gay and lesbian persons from securing the protection of state and local laws barring discrimination based on sexual orientation. The court had not yet recognized at that time any constitutional bar to discrimination based on sexual orientation. In fact, a decade earlier, the court in Bowers versus Hardwick had upheld against a liberty-based constitutional challenge a Georgia law that in criminalizing sodomy made gay sex a crime. The court did so based on what it determined history revealed about our country's past treatment of same-sex relations. The Romer court nonetheless ruled that the Colorado referendum violated the Equal Protection Clause. Justice Scalia ridiculed the decision in dissent. He highlighted late 19th century Supreme Court decisions that permitted discrimination against polygamists. He also pointed to the as yet unoverruled Bowers, and he then taunted the majority. What had changed besides a shift in present attitudes in some circles of society? Justice Scalia's question assumed, however, that the majority in Romer was trying to be au courant, as if it had discerned a contemporary trend and wanted to be trendy. But what if instead that court was anxious about history's future judgment? After all, Justice Kennedy's opinion in Romer began, most unusually, with a quotation from Justice Harlan's dissenting opinion in Plessy versus Ferguson, the case upholding Jim Crow that Brown overruled. 1 century ago, Justice Kennedy wrote, "The first Justice Harlan admonished this court that the Constitution," and here he's quoting Harlan, "neither knows nor tolerates classes among citizens." And then Justice Kennedy continued, "Unheeded then, those words now are understood to state a commitment to the law's neutrality where the rights of persons are at stake. The Equal Protection Clause enforces this principle, and today requires us to hold invalid a provision in Colorado's Constitution," unquote. That opening to that opinion by Justice Kennedy suggests to me that the court, and the majority of it, was worried that, just as over the course of 100 years, the court of history future had made Plessy a pariah, it might make Bowers one too, only sooner. And so the court in Romer had reason to be wary of deciding that case as if the court were only a court of history past, just as Bowers had decided to be. That may be why, even though the Romer court was not yet willing to overrule Bowers, and it was not willing to associate itself with that earlier ruling either. Indeed, it may be why the Romer Court was intent on acknowledging right up front, by invoking the Harlan dissent in Plessy, that it was quite aware of the Court of History Future and the retrospective judgments that it sometimes makes. In other words, the Romer Court was announcing that it knew the mistake history had taught that the court had made in Plessy, and that it would not make that same mistake again. Eventually, through a series of cases over the next 2 decades, in which Justice Kennedy each time wrote the majority opinion, Lawrence, Windsor, a companion version of which was first decided by my own court, and an opinion by Judge Boudin and joined by Judge Lynch, and Obergefell, the court rendered Bowers a Plessy-like artifact of the past, with the recognition of a constitutional right to same-sex marriage in Obergefell, playing the role of Brown in the drama. Justice Kennedy brought about that final act in an opinion in the same-sex marriage case, Obergefell, and he did it by building on Romer's opening words and setting forth as forthright a defense as any there is of interpreting a legal command to state a general principle that could then acquire meaning through what Justice Kennedy called, quote, new insight, unquote, gleaned from the experience of, quote, future generations, unquote, by, in other words, relying on history's unfolding judgment. That Justice Kennedy kicked off this line of precedent in Romer's very first paragraph by creatively misreading Justice Harlan's dissent in Plessy, so that it stated a general principle of equality that was uprooted from the context of Harlan's own time, and so was more expansive than Harlan himself had reason in his day to anticipate it would be, would have no doubt earned a knowing nod from Harold Bloom. If Justice Kennedy was anticipating history's future judgment, and not just reflecting its record of the past, his foresight so far has appeared to be true. When the court overruled Roe and Casey last term in Dobbs, on the ground that neither one of those precedents was itself deeply rooted in history, the majority denied the dissent's charge that the precedents in the Romer line were at risk as well. Here, too, the Court of History Future may be having its say. It is one thing to give effect to the past. It is another to be on the wrong side of history. The second example of how an appeal to the Court of History Future differs from the presentist orientation of President Roosevelt's defense of living constitutionalism comes from Justice Souter's concurring opinion in Glucksberg versus Washington, which rejected a constitutional right to physician-assisted suicide. To my mind, that opinion continues to offer the most fully reasoned modern articulation of how a right to liberty not deeply rooted in our history might be recognized. But it is not presentist in orientation. The majority's rationale in Glucksberg insisted that a court to be a court must be a court of history past. Justice Souter's own approach was more forward-looking. His concurrence repeatedly appealed to the judgment of the Court of History Future as if it were a sound interpretive guide. He first cited Dred Scott as a marker of how courts may go astray in recognizing constitutional limits on popular power, while noting, quote, the ensuing judgment of history needs no recounting here, unquote. And he cited Lochner for the same point. He then wound his way to an embrace of this passage from Justice Harlan II, not Harlan I, from a case in 1961, to explain how a court could rule in favor of the recognition of a new right to liberty in a way that history would judge well. Quote, the decision of an apparently novel claim must take its place in relation to what went before and further cut a channel for what is to come. The passage leaps from past to future without so much as mentioning the present. My third and final example of the difference between the presentism underlying Roosevelt's living constitutionalism and judging with the Court of History Future in mind comes from the Holmes lectures that the Yale Law professor Alexander Bickel gave in 1969 about the Warren Court. The most penetrating critic of the court, most often accused of making up rights based on a presentist mindset, Bickel, who had clerked for Justice Frankfurter during Brown, grasped in a way that cruder critiques of the Warren Court do not, that the justices on that court were trying to get on the right side of history, not ignore it. Quote, they bet on the future, unquote, he explained, content to, quote, take their chances, unquote. So aware was Bickle that the real judge in the matter was the history to come that he began his lectures criticizing the Warren Court with this admission, quote, "Historians a generation or two hence may barely note and care little about method, logic, or intellectual coherence, and may assess results in hindsight, only results, and by their own future lights," unquote. He then added, in commiseration with another estimable critic of the Warren Court, Herbert Wexler, quote, "Mr. Wexler has said that Brown," and here he's quoting Wexler, "has the best chance of making an enduring contribution to the quality of our society, of any decision that I know in recent years." And then, having finished quoting Wexler, Bickle said this, "Should that chance materialize, it isn't going to matter that Mr. Wexler thought that the decision rested on an inadequately neutral principle," unquote. Not surprisingly, Bickle used his lectures to take on the Warren Court's predictions about how history would unfold, rather than its authority to rely on those forecasts to interpret law. Ultimately, though, Bickle was concerned that the court's confidence in its ability to wager well on what was to come had led it to stop attending to methods that make a court, reason, care, caution, consistency. He expressed that concern most earnestly when he suggested that the court might be losing the public confidence it would need to answer what he predicted would be history's ultimate call for the court. Quote, "Is there not a chance that the judges might recall a riven society to its senses? If we should encounter not malapportionment, not inequality and social injustice, but a coup, a fundamental assault against broadly responsive government, might not this unique American institution just save us?" Unquote. Just as I have suggested that the invocation of the Court of History Future is not present-focused in the way President Roosevelt's argument for a living constitution was, neither is it policy-oriented in the way that an argument for pragmatic consequentialism is. The claimed focus of a judge focused on the Court of History Future is not on near-term consequences in the fashion of a policy analyst calculating costs and benefits. It is on imagining a future society that will make judgments about what we do today, identifying what those judgments will be, and drawing on those divinations to come to a decision not because it is of its time, but because it will stand the test of time. Justice Harlan, dissenting in Plessy, plainly had his eyes on where history was headed. So too did the unlikely heroes of the Fifth Circuit during the most challenging days of the Civil Rights Movement. It trivializes, in my view, the efforts of those Southern federal judges in dismantling a system of racial subjugation to suggest that they were acting out of a momentary pragmatic assessment. Indeed, Judge Minor Wisdom, and it's a pretty good name for a judge, a member of that court, wrote toward the tail end of that period about why a desegregation decision that he was authoring and that was said to be lacking in strong precedential roots was warranted. Quote, "In 1966, this remedy is the relief commanded by Brown, the Constitution, the past, the present, and the wavy foreimage of the future." And he said future with a capital F. In the same vein, consider how much the prospect of future judgment, rather than pragmatic calculation, influenced the kinds of decisions that judges all stripes regularly, even today, invoke to explain why judicial review is worth preserving. Facing down the likes of Dred Scott and Plessy, Lochner and Korematsu, the pantheon includes not only Brown, but also the Steele Caesar case, neither of which simply reflects an unoriginal understanding. Indeed, Justice Robert Jackson, the author of the most admired of the many opinions in that latter case, which was decided during the Korean War, made no secret that the past offered little instruction about whether a president could seize an industry during a war de facto to bring about labor peace. But in the face of a history of debates over war powers that Jackson described as no more intelligible to a judge than the dreams of the Pharaoh were to Joseph, that justice did not find refuge in a consequentialist calculation. His concern, as I read him, was that history would not look kindly on a court that permitted executive absolutism to take hold under our constitutional system. And that was so even if a toting up of costs and benefits might support a little bit of authoritarianism by Harry Truman, hardly a dictator in waiting. As Justice Jackson put it in contemplating history's future judgment in that case, quote, "No penance would ever expiate the sin against free government of holding that a president can escape control of executive powers by law through assuming the military role," unquote. Justice Jackson had good reason to approach his decision in that case in that way. His eyes had been fixed on the judgment of history only years before, when he had served as the chief prosecutor at Nuremberg and opened that trial for the ages about the unspeakable danger of executive absolutism with this, quote, "We must never forget that the record on which we judge these defendants is the record on which history will judge us tomorrow," unquote. Part 3, and you'll be glad to know the final part. How then should a court account for the judgment of the court of history future? I am sorry to have kept you in suspense this long in waiting for my answer. But like all fundamental questions about the nature of identity, this one also occasions anxiety, albeit an anxiety born of a judicial worry that the past may have too great a hold, even though it is surely supposed to have a strong one. Predictably, then, judges will not give you a straight answer. They often respond to this question indirectly by asking questions of their own, and I have two in mind. Who cares? And who knows? Those two questions are both best understood, in my view, as means of stress relief, but they are not the same question. The first asks, who cares how history will judge? The second asks, who knows how it will judge? By taking each question seriously, I hope to persuade you that although the who knows answer cannot be ignored in accounting for the court of history future, the who cares answer cannot be accepted as a ground for not accounting for the court of history future at all. Justice Scalia nicely articulated the who cares response in a case that concerned an equal protection challenge to the Virginia Military Institute's exclusion of women from its student body. Justice Ginsburg closed her opinion for the court striking down that policy by asserting that, quote, "A prime part of the history of our Constitution is the story of the extension of constitutional rights and protections to people once ignored and excluded," end of quote. Justice Scalia replied as follows with characteristic verve, quote, "The virtue of a democratic system is that it readily enables the people, over time, to be persuaded that what they took for granted is not so, and to change their laws accordingly. That system is destroyed if the smug assurances of each age are removed from the democratic process and written into the Constitution," unquote. In this passage, Justice Scalia does not deny that future generations will cast judgment on what judges do today. He contends only that it should be of no interest to judges that those generations will. There is in each age, he suggests, just the smug assurances of that age. And so judges, as legal interpreters, must confine themselves to identifying what was, not writing into the law what has come to be or what will be. This response depends on an implicit claim about the temporal fixedness of the equal protection command. But judgments of the Court of History future and the prospect of its judgments themselves have shaped our equal protection law. The response thus ignores the doubt that the Court of History future cast on Korematsu and Plessy, and the harsh indictment of them that we now understand that future court to have handed down. It ignores, too, the high esteem that time has bestowed on Brown, even though Brown was hardly beyond reproach in its day. It ignores even Justice McLean's dissenting appeal to the Court of History future in Dred Scott, in which he explained that he would not opt for a discriminatory reading of the word, quote, citizen, unquote, in the Constitution, based on what he called, quote, so dark a ground, unquote, as the framers' toleration of slavery, when history had moved on by banning the trade in persons, and he asserted, most debatably, yet hopefully, quote, everybody knew at the founding where history was heading, unquote. One finds another who cares response in a 2020 case from the 11th Circuit. It involved a federal constitutional challenge to a Florida law impeding felons from voting. The dissent in that case appealed to the circuit's past, given that the 11th Circuit was carved out of the 5th Circuit. The dissent sought to make a point about how poorly history would judge the decisions to uphold the Florida law. Quote, "Our predecessor, the former Fifth Circuit, has been rightly praised for its landmark decisions on voting rights in the 1950s and 60s. I doubt that today's decision will be viewed as kindly by history," unquote. The majority responded this way. Quote, "Our duty is not to reach the outcomes we think will please whoever comes to sit on the court of human history," unquote. As a court with, quote, "limited jurisdiction," unquote, it was obliged instead, the majority said, to, quote, "respect the political decisions made by the people of Florida and their officials within the bounds of our supreme law, regardless of whether we agree with those decisions," unquote. This response, by contrasting law with present-day judicial preference or agreement with outcomes, does not directly address the dissent's prediction about the judgment that future generations would make. Nor does it deny that some judicial work is best evaluated only after the history to come has had its say. Indeed, the majority acknowledged the, quote, "heroic," unquote, quality of the predecessor judges of the Fifth Circuit without trying to show that their heroism owed only to their fidelity to the past, a showing that would have been hard to make, as the reference to Judge Wisdom's to the future's compulsory foreimage that I mentioned earlier indicates. The majority ultimately did, in the 11th Circuit case, hazard an explanation of why the judgment of, quote, "the court of human history," unquote, did not matter. It explained that answer this way, quote, "In the end, as our judicial oath acknowledges, we will answer for our work to the judge who sits outside of human history," unquote. This version of the "who cares" response does not deny the anxiety of influence so much as it displaces it to a realm beyond human history, and so, by definition, beyond law. Yet if a judge must be answerable to future judgment, why only to God's and not posterity's? We have seen how our legal tradition internalizes the judgments of posterity. And while Jefferson famously said that he trembled for his country when he reflected that God was just, in good Enlightenment fashion, he also was quite cognizant of what he called the, quote, "bar of posterity," unquote. Indeed, the Constitution announces at the outset that, quote, "we the people," unquote, established the Constitution to, quote, "secure the blessings of liberty to ourselves and our posterity," unquote. In other words, neither the claim that law is temporally fixed nor the invocation of an individual judge's immortality satisfactorily faces up to the force of the appeal to the judgment that the court of history future may render. Each response just insists that our legal tradition is as resolutely backward-looking as it is claimed that the present-day judge must be. There is, however, another type of response to the invocation of the court of history future, and it also takes the form of a question. The question is, who knows? Here again, as with so many things, Justice Scalia well articulates the point. Dissenting in Planned Parenthood versus Casey, which had reaffirmed the right to abortion first recognized in Roe, Justice Scalia vividly called to mind the portrait of Dred Scott's author, Chief Justice Roger Taney, that still hangs in the Supreme Court. Justice Scalia did so to make a point about the difficulty of anticipating what the future holds. Quote, "There seems to be on his face and in his deep-set eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon the happiest of thoughts. But those of us who know how the luster of his great Chief Justiceship came to be eclipsed by Dred Scott cannot help but believing that he had that case burning on his mind," unquote. Justice Scalia does not deny in this passage that Justice Taney cared about history's future judgment. Indeed, Justice Scalia imagines that Taney was understandably all but consumed by it. But Justice Scalia contends that Justice Taney was wrong to think that he could anticipate what would follow in Dred Scott's wake. So too was the Casey court wrong to anticipate that its ruling could settle the abortion controversy. Quote, "It is no more realistic for us in this litigation than it was for Taney in that, to think that an issue of the sort they both involved can be speedily and finally settled in the Supreme Court," unquote. The "who knows" response acknowledges the anxiety that the prospect of history's future judgment occasions in a way that the "who cares" response does not. It substitutes for a highly contestable claim about what law is, or about to whom a judge is answerable, an all but indisputable claim about the limits of human knowledge. The who knows response thus usefully reminds a court too confident of its far-seeing ways that it may be finding in the future merely what it wishes for today. That was, in fact, Bickle's critique of the Warren Court, which he charged with building a heavenly city of its own, imagining, in the name of merely anticipating what it mistakenly thought was history's inevitable progress. But the who knows response, because Prudential is an equal opportunity employer, it may be easily turned on a court too sure of its ability to divine the past and too sure that only the past need be divined. We may be tempted to think that the past is just there waiting to be found, while history's future judgment is inherently beyond knowing. But that dichotomy is surely too sharp. Chief Justice Roberts and Justice Kavanaugh each pointed to judgments they thought the Court of History Future had already handed down. Judgments like that are no harder to find than is any artifact of public meaning, original or otherwise. True, a judgment by the Court of History Future that has not yet been made is not knowable in the same way as a judgment by that court that already has been made. But predicting the future is sometimes easier than discerning the past. Justice Jackson certainly thought the past more inscrutable when it came to war powers than the future's judgment would be about where the balance in their exercise properly lay. It is worth remembering, too, that sophisticated defenders of originalism no longer assert that the method's virtue inheres in the easy-to-access answers that it supplies. That's in part because time travel in any direction is always somewhat fantastical. But it is also because they acknowledge that controversial cases often turn on interpretive disputes about levels of generality, and so what it is that we're actually looking for from the past, applications or principles. Thus, just as there is risk in judging based on forecasts of what is to come, there is risk in judging based on assessments of what has already been. Heavenly cities may be based on imagined pasts as easily as on imagined futures. If the forward-looking judge risks imagining a future in the judge's own pro-progress image, the backward-looking judge risks adhering to a narrow view of the past out of the judge's own commitment that change must be resisted. Edmund Burke, it should be recalled, argued for looking for guidance to the past rather than to posterity's judgment because he thought it best for the past to persist. Admittedly, the counsel of prudence that the who knows questions offers to a court that sits, as I am suggesting all courts do, between the Court of History Past and the Court of History Future may seem like no counsel at all. Such counsel cautions against the too ready recognition of what is new and the fetishization of what is old. Yet, what kind of caution is that? To live in time is to inhabit both the space of experience and the horizon of expectation, and we know both that we have no reason to expect the future to bring more of the same, and no ready means of anticipating what it will bring. Nonetheless, the prudent counsel of the who knows response at least appreciates the anxiety of influence that the Court of History Future occasions. It requires those partial to looking forward to face up to the perils of doing so, but it also reminds judges, convinced of the need to look back and only back, not to mistake a legal tradition that has been informed by a concern about history's future judgment, as if it were in fact a tradition that is untainted by any such concern. For to make a mistake of that kind is to misread a tradition that has accommodated great change over time, as if it were designed to be a system that would permit no more such change ever to occur. It is thus to imagine, in the name of fidelity to history, that the end of history has arrived. For that reason, I'm convinced that while it's fair to ask in response to an invocation of the Court of History Future, who knows, it is a mistake to respond, who cares? For because courts long have cared and still do about the future and what it will have to say, that latter response risks encouraging defenders of the Court of History Past to try to have their cake and eat it too, to confidently reject all calls for the need to look forward, even while claiming to throw no shade thereby on forward-looking rulings that the Court of History Future has affirmed, Brown first and foremost among them. In this connection, it's useful to recall, and here I'm almost at the end, a question at the heart of Dobbs, which overruled Casey and Roe, chiefly because each recognized a right without deep roots in the past. To explain why precedent so long in place did not warrant the respect that precedent usually does, the Dobbs courts highlighted a critical question. Isn't any decision as egregiously wrong as Plessy no more worthy of respect than Plessy itself? If in asking that question, a court is acknowledging all the history that followed Plessy, and thus all the history that proved the first Justice Harlan right, in predicting in dissent in that case that, quote, the judgment this day rendered in time will prove to be quite as pernicious as the decision made by the tribunal in the Dred Scott case, unquote, then I think that a court is asking a question similar to the one that Chief Justice Roberts asked of Korematsu in Trump versus Hawaii, and thus quite a good one. For a court is then asking whether the history that followed, or will follow, the precedent at hand, reveals that precedent to have been, or will reveal it to be, as unworthy of respect as the history that followed Plessy showed, in retrospect, it to have been when it was decided. But if, in asking that question, a court is asking only whether the precedent at hand recognized a right that is itself deeply rooted in the past, then such a court is not relating to history so much as creatively misreading it. For in asking only that question, such a court is forgetting that there are two senses of the court of history that influence what judges do, not only one, because such a court is then forgetting that it is history's retrospective judgment that makes Plessy a present-day marker of a court gone wrong. Indeed, without the court of history's future's harsh judgment of Plessy lighting the way, what, quote, opportunity, unquote, would there be to announce, without even the prospect of contemporary dispute, what the court announced in Dobbs in echoing Harlan's dissent in Plessy, that, as the Dobbs court rightly put it, Plessy, quote, betrayed our commitment to the principle of equality. That announcement draws its unchallenged acceptance by leveraging the history that followed Plessy, a history that paved the way not only for Brown, but also for Brown's vindication in history's eyes. And then that statement further leverages that history by invoking, quote, our commitment to the principle of equality, in terms that, through the expansive use of the word our, are open-ended enough and inclusive enough to permit new understandings of it, as not only Brown but also Romer showed when the court in that latter case invoked Plessy's dissent to make room for the, quote, new insight, unquote, gained from, quote, future generations, unquote, that not even Brown's authors could foresee. Courts that forget history rarely judge well, no matter how much they seek to adhere to it. So just as a court that cares nothing of the past cannot do its work well, neither can a court that proceeds as if history has stopped. Judge not, lest ye be judged is no option for the judge charged with resolving a dispute. Thus, so long as courts retain the power to resolve whether novel rights may be recognized or may be overruled after having been many decades in place, they must keep both the court of history past and the court of history future in mind. Otherwise, they will be ill-equipped to make the kind of prudential judgments about the relationship between past, present, and future that in American law have long determined legal meaning. Will history judge kindly a kind of judging that looks in only one direction and then only back? We cannot know for sure the answer to that question from where we sit. I hope I've convinced you, though, that, even from where we sit, we should care about the answer that the Court of History Future would give, and so do our best to clearly account for that answer in deciding how to judge today.
Judge Barron has agreed to take some questions, and I'm going to use my privilege aggressively to ask him the first question. So, who cares and who knows? On the who knows, I'm assuming there's some kinds of cases that trigger these questions and these anxieties more than others. So which are those cases? And can a judge sitting today deciding a case that pops up in front of the judge or the judge's panel know the case, this is the one where I have to think about the court of history?
It's a great question, Troy, and I guess I answer it in three different things come to mind. One is from an experience not being on a court at all, but being at the Office of Legal Counsel, where Troy was a deputy himself in the Justice Department. One of the most worrisome things about being in that office is that you don't talk to anybody. And you don't get briefs, you don't have parties, and you're making these consequential legal decisions, but sometimes you don't know how anybody will think about it. In fact, nobody knows you're making it. That's a quite frightening experience for a legal decision maker, and partly for the very reason you say. You know, you're hearing from all these people who say it's no big deal. And within the little world you're in, it didn't seem like that big a deal until it hits the light of day, and then people think it's quite a big deal. That can happen, I think, on the bench, but I think there's less likelihood of it precisely because it's an open process with advocates who are making those kind of claims to each other, and particularly on a court where you have other judges on it, there's the chance, the hope that someone in dissent will wake you up if you're not seeing the stakes of a decision. So there's that check on it. But I think there's another dimension to it, which is clearly it's certain kinds of high-stake cases. I mean, the judges in the Steele seizure case clearly were aware of the stakes of that case. In fact, one thing that really strikes me is that the word anxiety appears in both Frankfurter's decision and Jackson's, and it's not a word you see every day in a judicial opinion. So they knew how stressful and big a deal that choice was. But I think a danger for judges is that we, in the mine run of cases, decide zillions of them. And it's the pattern of them over time where we may not have given consideration to what it will look like 30, 40 years down the road that I think tends to haunt some judges. I know it haunted judges who were doing the initial engagement with the sentencing guidelines and mandatory minimums. I think having the routine of doing it, I think it occurred to them, this can't be how we're supposed to do this job. And it'll look like we can't have been. I do think about it sometimes with prison conditions cases, I must say. You know, what are the conditions in these prisons, and what is the law that we're applying? Two, it's very hard to get access from where we sit often to fully know, but there is that worry in the background. Our old boss, Justice Stevens, I think with the death penalty, had somewhat of that experience over time, as many judges have.
Questions? I see a hand right there.
Well, I'll try it without point. Isn't it true that the common law reinforces your view of history? Because the common law as a body of law is history, but the process of how we change in the common law is also a way to go forward without being stuck in the past. And the Scalia recognized that in Heller when he says, well, we're not going to take the definition of arms as it was in 1789 or the definition of speech, we're going to use the modern definition. Doesn't that really destroy any idea of soundness to textualism and originalism? They can't exist when the common law is essential to the interpretation of the Constitution, which it is, and the common law is structured process-wise in such a way that it changes every day, every time a judge makes a new decision. So we have in place a process that works. And when we decide to approve New York City's water system in the 1840s on a forward-looking basis, or environmental rules, or speed limits, which speed limits anticipate people are going to go faster in the future, and that harm will be caused. And they say we want to prevent it. So we're doing all of that, and we're doing through the use of the common law.
Yeah, well, I think I don't want to have a debate about originalism as such. I mean, there's many sophisticated points back and forth on all of these things and the way the common law does or does not reflect how you interpret a constitution or a statute. And there's many iterations of it, but the basic thrust of it, that deep in our legal tradition and an important strain of it, contemplates change of a kind, partly by imagining what's to come and then relating it to what has occurred, that's definitely a piece of the tradition that I'm drawing off of, and that I think the judges that I'm quoting, from Chief Justice Roberts all the way through, even sometimes the Justice Scalia himself are aware of. The piece that I think came through to me that I don't think is reflected on enough, and this may be an intuition I have from my own experience of having had some high-stakes legal decisions to make, both in government, before being on the bench, and then being on the bench, is that the future's judgment of what you're doing, I think, is a catalyst for decisional confidence, and also for decisional anxiety. I think when we think about it externally, and we try and imagine what judges are doing, and we see what the patterns are, it's hard to get inside the experience of having to make the decision and the responsibility that comes with making it. And I guess it's that what really struck me most about these appeals to the judgment of a future court or decision maker and the power that can hold on a present-day decision maker. You know, both in terms of, and that's why I think the who knows question is such a relevant question, because you can trick yourself into thinking you know how you'll be judged. Well, you don't, really. And so maybe the right answer is, put it out of your head. You can't think about that. And yet, the minute you put it out of your head, you think, maybe I shouldn't have put that out of my head. And it's I think, that tension. That's why I think the use of the word anxiety captures to some extent that difficulty.
Another question. Yes.
I hope this works. My mom tells me that I'm very loud, so it should. I'm an undergraduate, so I might have a very naive question, but you've talked a lot about kind of the court reflecting on itself over time, and I guess if I may be a little bit brusque, that you kind of defined the judge as a very almost philosophically lonely character who's kind of a martyr, so to speak, who has to contemplate these metaphorical problems that maybe the average citizen doesn't have to. And I guess in that regard, you talk a lot about the court self-examining and judges self-examining as a unit of the court. But how in your career did you self-examine through time? And to what sources do you look to establish this sense of existence as a judge in this capacity?
Yeah, that's a powerful question and a completely fair one. I think each judge has their own experiences that lead them to the bench and that cause you to be chosen. And those are the experiences, I think, as much as you try and reflect in the job by engaging with your colleagues and taking seriously the process of adjudication, which is, after all, how we decide things. Sticking to the briefs, the arguments made, trying to take seriously what the precedents are, those materials which are the ultimate, or the actual material that we draw on, and that's supposed to be the process examination. Each of us does come with a life history that brings you to the bench with the experiences you've had, of decisions you've had to make, of people you've encountered, of places you've been, of ways you've interacted with the world. That's the main reason, I think, why there's been a greater and greater appreciation of the need for diversity on the bench, because the more people with more backgrounds that interact with one another, the more likely there is to be a check on the kind of worry that I take to be implicit in your question. I will say, though, there is another dimension to it, which is, there is engagement now among many in the public about who are these characters, these judges, and why are they deciding all these things? And that's part of the reaction to judges deciding things in ways that seem too broad, too categorical, too definitive. It's a difficult tension because people also depend on rights, and rights are meaningful to some extent when they are stated fairly strongly. So people, I think, in their own minds are a little bit betwixt and between as to what they want in terms of a culture in which rights can be defined that way. But I think your question is getting at what I think a lot of people are feeling now.
Maybe time for a couple more questions? Yes, right there.
I want to just maybe challenge or ask you about the dichotomy on the who cares and the who knows. Because I get a sense from some of these decisions that the who cares, I mean, it sounds very dismissive. I don't consider myself to be in that camp, but I think it's a lot of it is perhaps derivative.
Of a who knows.
Who knows? It's like, okay, I would care more if I knew. I mean, if you're using the 11th Circuit cases as an example with the felon voting, one can easily envision a world where, in the future, where it's perfectly legitimate to say, okay, there have been threats to democracy. We don't think that anybody who participated in any insurrection and was convicted of it, even if they served their time, should ever vote, for example. It seems to me, therefore, that a lot of the who cares that is in that decision is really maybe just who knows. Am I barking up the wrong tree?
No, I think it's the right tree. I do think there is a difference between what you're defining as a great deal of skepticism and the importance of holding on to that, and not worrying about whether you need to be skeptical because it simply can't matter. And I think those are two very different perspectives with different consequences. And I guess if I had to give you an example of what it means to embrace the skepticism without embracing the who cares, I'd just refer back to Justice Souter's concurrence in Glucksberg. That opinion is one long who knows on the right to physician-assisted suicide. And it's also one long explanation for rejecting who cares. So I think it's perfectly possible to have both positions, and he really exemplifies that.
One more question. There's a strange person in the back. Trevor, how are you?
I must say, I like sitting at this end of the room. David, thank you. That was just an utterly spectacular lecture. I'm looking forward already to reading it in print. So I'm wondering, supposing we were in a situation where answering the who knows question didn't feel impossible. That is, the judge thought they had a sense of what the court of history future was likely to say. When does that sense do actual work? And so here's the suggestion. I'm not sure that I myself believe it, but I wonder what you think about it. That it only does work when the judge finds themselves at odds with what they think the court of history future would say. If I think this case should come out a particular way, and I think the court of history future is likely to think that was the right way to go, then it's overdetermined. And the real question, the real work for this sense of trying to be attentive to the future is when what you otherwise think would be the right answer, you think is going to be judged harshly by history. Is that a fair sort of kind of homing in on?
Yeah, I think the gap that to me it misses is that to make a decision as a judge and particularly a decision that recognizes a novel right that's going to limit what politics can do, is a step beyond thinking what's the right answer. You know, you can have a certain amount of confidence that if I was deciding this is what I would do. You might even have a certain amount of confidence that if I wasn't a judge and I thought I was a judge, here's what I would do. But now I'm a judge and I'm actually doing it. And that's another step. And in my experience, that sense that that history would look on this wrong. I'm doing what I'm supposed to do. I mean, I don't know if the other judges in the room, this has any kind of grip with you, and it may not, and so it may just be personal. But I will say this, I think people overestimate the degree to which judges want to be popular. I don't think for most judges it's all that hard to make a decision that's not popular. You just wouldn't get into the job. Really, there are other things you could do. So, but I think it is very troubling to a judge to think, I authored one of those cases that's in that quartet. No judge wants to do that. And I think that was essentially what Scalia was trying to say about Taney, right? And I think that really does, if you feel that to some extent. So I don't know how responsive that is, but I think that's the work it does.
Well, please join me in thanking Chief Judge Barron.